was made possible by CuriosityStream and Nebula. There's another full-length companion video all about anti-slap laws, which you can access by signing up for the CuriosityStream Nebula bundle for less than $15 a year at the link below. Kyle Rittenhouse is out for blood. No, not that kind. He's out to get revenge on anyone that called him a murderer, and he has specifically named Whoopi Goldberg, Cenk Uygur, LeBron James, and Joe Biden. Now, unless you've been living under a rock for the past couple of years, then you probably know who Kyle Rittenhouse is. But for those who need a brief refresher, in 2021, a jury acquitted Rittenhouse for homicide, attempted homicide, and reckless endangerment in connection with the deaths of Joseph Rosenbaum, Anthony Huber, and the wounding of Gage Grauskreutz. Rittenhouse shot these individuals during the unrest surrounding the 2020 racial justice protests in Kenosha, Wisconsin. The jury likely concluded that Rittenhouse had acted in self-defense and therefore was not criminally liable for the shootings. Now, the reactions to the verdict and the case itself were predictably polarizing along partisan lines. Many Americans on the political right, notably gun rights groups and far-right members of Congress, celebrated Rittenhouse as a folk hero, painting him as a crusader for justice who had stood up against a raging mob.
Kyle Rittenhouse is not guilty, my friends. You have a right to defend yourselves.
Rittenhouse even took a months-long victory lap in MAGA country, meeting with Donald Trump at Mar-a-Lago, giving interviews to Tucker Carlson. In contrast, many Americans on the political left viewed the verdict as a jury-sanctioned endorsement of armed vigilante justice. Rittenhouse's critics have routinely savaged him as a murderer, white supremacist, and even a domestic terrorist.
A 17-year-old vigilante, arguably a domestic terrorist, picked up a rifle, drove to a different state to shoot people.
And since his acquittal, Rittenhouse has declared his intention to strike back against his critics through the power of the almighty lawsuit. In a February 2022 interview with Tucker Carlson, Rittenhouse announced the creation of the Media Accountability Project, which Rittenhouse described as, quote, a tool to help fundraise and hold the media accountable for the lies they said and deal with them in court. Rittenhouse told Carlson that he planned to bring defamation lawsuits against anyone who called him a white supremacist or a murderer, specifically naming The View's Whoopi Goldberg and the host of the Young Turks program, Cenk Uygur, for characterizing his killings as murder even after his acquittal. Rittenhouse has also said he plans to sue LeBron James for suggesting his tears during the trial were fake, and Joe Biden for his campaign tweeting out a video linking Rittenhouse to white supremacy in 2020. So today, Legal Eagles, let's think like a defamation lawyer and attempt to answer the $64 million legal question: what is Kyle Rittenhouse's likelihood of prevailing on the merits of this threatened litigation? Now first, let's talk about the basics of defamation law. What does it mean to defame someone? Well, simply put, defamation is a tort that creates civil liability for the publication of a false statement about a third party that unjustly injures another's reputation. Now, there's no federal defamation statute, and states may define defamation in slightly different ways, but to prove defamation, generally, a plaintiff must typically establish 4 basic elements of their claim. First, a plaintiff has to make a false statement, a verifiable fact. A verifiable fact is an assertion that is capable of being definitively proven true or false. In contrast, statements of opinion that cannot be understood by a reasonable listener to be literal assertions of fact are not defamatory, though simply labeling a statement as your opinion doesn't make it so either.
You said that, in your opinion, kindling is the best wood to start a fire.
Well, isn't it, Hank?
Of course it is, but it's not your opinion. It's a known fact.
Now second, the false statement has to be made to a third person. This communication or publication can be either verbal or written, but it has to be to someone other than the subject of the defamation. Now third, the party publishing the false statement has to have some fault in disseminating the defamatory communication. This amount of fault one needs to show depends on whether the defamed individual is a private figure or a public figure. A private figure claiming defamation, such as a neighbor, or store clerk, or a barista, only has to show negligent publication, meaning that a reasonable person would not have published the defamatory statement, or a reasonable person would have known that it was false. Now, a public figure like a celebrity or a member of Congress or a presidential candidate has to prove actual malice, meaning that the defendant made a statement either knowing that it was false or acting in reckless disregard for the truth. Now, the standard also applies to a limited purpose public figure, who is one who voluntarily participates in a discussion about a public controversy and has access to the media to get his or her views across. Now, under the standard, Rittenhouse probably qualifies as a limited purpose public figure, which means that only specific false factual assertions harmful to his reputation that were known to be untrue or were made in reckless disregard of the truth would give rise to defamation in this case. In other words, Rittenhouse is subject to the higher standard. And then finally, the fourth element of defamation is the subject of the statement has to have suffered some kind of quantifiable damages. Now, at the same time, there is something called defamation per se. Now, a lot of people get this wrong. Defamation per se means that if you have made a defamatory statement in one of these categories, damages are presumed for liability. It doesn't mean defamation is automatic, it just means you don't have to show damages right off the bat. That happens when you claim that someone is involved in criminal activity, has a loathsome, contagious, or infectious disease, was unchaste or engaged in sexual misconduct, or has engaged in conduct incompatible with the proper conduct of one's business or profession. Now, this came about in the Cardi B affair, where someone claimed that Cardi B had an STI. Now, that qualified as defamation per se, but again, you still have to prove defamation. It just means you can skip damages for the first time around. So with that understanding, let's look to the potential targets of litigation from Rittenhouse. And we start with the king himself, LeBron James. Now, when Rittenhouse took to the stand in his own defense, he famously got emotional and broke down in tears during his testimony. LeBron questioned the tears and suggested that he had some lemon heads before taking the stand. Now, it's not clear that there are any other allegedly defamatory statements that Rittenhouse would rely upon for potential action against the ball player turned Space Jam 2 star, but this tweet was the only publication that had been cited in news reports for Kyle's hypothetical defamation suit. So if Rittenhouse attempted to sue based on this tweet alone, he would surely fail on the grounds that this is James's opinion and not a defamatory fact. Rittenhouse would have to show that James was making an assertion of verifiable fact capable of being proven true or false. But internal thoughts or feelings, by their very nature, cannot be proven true or false, no matter how much another insists that they are being sincere. And here, we all saw the footage, and here it's just LeBron opining based on the facts that everyone else could see. And just as The Wire's Omar Little had a saying, if Kyle decides to take on King James based on this single tweet, well, he's probably going to miss pretty badly.
You come at the king, you best not miss.
But next, can Rittenhouse sue Joe Biden and others for defamation for suggesting that he's a white supremacist or domestic terrorist? Now, some conservative attorneys and commentators have called for Rittenhouse to bring defamation actions against anyone from TV pundits to President Joe Biden for purportedly linking him to white supremacists. For example, MSNBC's Tiffany Cross referred to Rittenhouse after the verdict as, quote, this little murderous white supremacist. Journalist John Heilemann appeared on MSNBC, described Rittenhouse as, quote, arguably a domestic terrorist. And during the 2020 campaign, Joe Biden's Twitter account shared a video condemning Donald Trump for failing to denounce white supremacy and other far-right groups, which included footage of Rittenhouse. So herein lies the question. Does Rittenhouse have a defamation cause of action for being called a white supremacist or domestic terrorist? Answer, probably not. Well, for starters, courts have repeatedly held broad labels that describe someone's beliefs like racist or white supremacist or even terrorist are generally non-defamatory opinions. For example, in Brimelow versus the New York Times Company, a federal judge held that the New York Times article describing a prominent opponent of non-white immigration as, quote, a white nationalist, white supremacist, and anti-Semitic were non-actionable opinions. The lawsuit was dismissed, and the dismissal was affirmed on appeal. Furthermore, the US Supreme Court has highlighted that the right to use hyperbolic language and make figurative exaggerations are necessary for spirited public debate. For example, in the case Milkovich versus the Lorraine Journal, the Supreme Court said, quote, the Constitution protects statements that cannot reasonably be interpreted as stating actual facts about an individual made in debate over public matters in order to provide assurance that public debate will not suffer for lack of imaginative expression or the rhetorical hyperbole, which has traditionally added much to the discourse of our nation. Now, Milkovich and subsequent cases have held rhetorical hyperbole can be a valid defense to defamation if the statements are found to constitute opinions. And statements that are full of exaggeration and innuendo or are just asking questions are more likely to be deemed hyperbolic opinions rather than statements of unambiguous fact. And in 2020, a judge dismissed a defamation claim against Rachel Maddow on the grounds that she had engaged in rhetorical hyperbole. The lawsuit was brought after Maddow told viewers of her show that the conservative news network OANN, quote, really literally is paid Russian propaganda. The court agreed that while Maddow did exaggerate the facts by calling OANN Russian propaganda, her statement in context was found to be, quote, consistent with her tone up to that point, and a reasonable viewer would not take the statement as factual given the context. The context of Maddow's statement shows reasonable viewers would consider the contested statement to be her opinion. And in support of this conclusion, the court noted that Merriam-Webster's own definition of the word literally now includes a secondary defamation to mean, quote, in effect, virtually, used in an exaggerated way to emphasize a statement or description that is not literally true or possible. Now, legally, the court came to the correct decision. Now, linguistically, I can't. I refuse to accept that literally now means figuratively, just because everyone misused the word enough that the dictionary said, fine, whatever, literally now means not literally now. And they use the word literally to contradict the term. It's insane.
I literally want to rip your head off.
You mean figuratively?
No, I literally mean literally.
That being said, it was still rhetorical hyperbole. And the same probably goes for the white supremacist label as well, in part because of Rittenhouse's own willing association with the far-right Proud Boys, which invited people to make reasonable commentary on his personal views. For example, in January 2021, Rittenhouse was photographed and recorded in a Mount Pleasant bar being serenaded by members of the Proud Boys, a self-described, quote, Western chauvinist group whom the FBI labeled in 2018 as an extremist group with white nationalist ties. At the bar, Rittenhouse posed for photos holding up the OK hand gesture with the Proud Boy members. That hand gesture has been co-opted by white supremacists, maybe ironically, maybe not ironically, it depends on who you ask. But Rittenhouse and his lawyers have long argued that Rittenhouse does not belong to any far-right groups and is not racist. Rittenhouse's lawyers successfully excluded evidence from the jury that any purported ties to the Proud Boys. And Rittenhouse even told Tucker Carlson after his acquittal that he supports Black Lives Matter. And as one pundit put it, quote, the perception that Rittenhouse is a racist may be incorrect, but it's not unreasonable. If someone had published an article saying Kyle Rittenhouse is a member of a white supremacist organization, that is a statement of fact and can be proven true or untrue. But if an article said he posed with the Proud Boys and flashed a white supremacist sign and is a white supremacist, that may be an incorrect conclusion, but it's a reasonable one. It may also qualify as an opinion. And on top of that, since Kyle Rittenhouse is probably a public figure at this point, unless Rittenhouse can point to specific news reports claiming he definitively belongs to a white supremacist group or group that calls for engaging in domestic terrorism, as opposed to speculation that he personally holds such views, it's unlikely that Rittenhouse will succeed to sue anyone for calling him a racist, a white supremacist, or a domestic terrorist, whether you're talking about Rachel Maddow or Joe Biden. It's probably not going to work. But then there's the question of, can Rittenhouse sue the mainstream media or politicians for calling him a murderer? Now, this was going on a lot. And the issue of whether Rittenhouse could sue pundits or politicians for calling him a murderer is probably closer than the prior two questions. Shortly after Rittenhouse was acquitted in November of 2021, Whoopi Goldberg, for example, said on The View that she still believed he was guilty.
Even all the excuses in the world does not change the fact that 3 people got shot. To me, it's murder. I'm sorry.
And Rittenhouse told Tucker Carlson that people like Whoopi Goldberg defamed him by calling him a murderer even after being acquitted. So the question is he right? Well, to give everyone's favorite answer, it depends, but probably not. Now, legally speaking, the jury found Rittenhouse not guilty. And the only thing that you can surmise as a result of that verdict is that the prosecution didn't meet its burden, that there might have been reasonable doubts. The jury might also have believed that Rittenhouse acted in self-defense, but you can't necessarily know exactly what they meant from the fact that they found him not guilty. It isn't necessarily a repudiation of the idea that he committed murder. Though, if I was representing Rittenhouse, I would probably point it as very strong evidence that he did not, in fact, commit murder, especially under these circumstances. And the statement that someone is a murderer or committed murder could be a little bit more dicey. And as explained by First Amendment scholar and my former law professor Eugene Volokh, if a statement that Rittenhouse is a murderer implies the speaker knows undisclosed or unpublicized facts that could implicate him, that could potentially be defamatory. For example, if a pundit stated, quote, I had a conversation with Rittenhouse yesterday and he told me a lot about what happened, the man is a murderer, that could be an actionable factual assertion. In contrast, if the statement merely expresses the speaker's opinion based on the public facts that have been discussed and publicly disclosed, that's probably not actionable. So if a pundit were to say, I've watched a lot of coverage of the case and the jury got it wrong, the man is a murderer, that is likely a non-actionable opinion. So generally speaking, when people referred to Rittenhouse as a murderer, It probably wouldn't have been defamatory because people wouldn't have any reason to believe that the speakers had inside knowledge beyond what had been reported in the news. And of course, there was lots and lots of news coverage. Now, a similar case happened when radio host Bob Lonsberry referred to John Giselle, who had been acquitted of negligent homicide after shooting a man to death in a hunting accident, as a cold-blooded murderer on air, and asserting that the fatal shooting, quote, could not have been an accident. The court reasoned that Lonsberry's statements were based on facts widely reported by the media and could not reasonably be interpreted by listeners as being based on undisclosed information. And furthermore, these statements were, in the words of the court, quote, obviously intended to be confrontational rather than factual. And thus there was non-actionable expression of pure opinion. And of course it goes both ways. Tucker Carlson accused a public figure of a crime and was rescued from defamation thanks to his own rhetorical hyperbole. As you may know, in 2020, model and actress Karen McDougal, who allegedly was paid $150,000 to keep quiet about an affair with Donald Trump, sued Fox News for defamation after Tucker Carlson accused her on his program of engaging in, quote, a classic case of extortion against Donald Trump. And in getting the case dismissed, Fox News successfully argued the general tenor of Tucker Carlson's show puts viewers on notice that his statements should not be taken literally. Quote, Tucker Carlson is not stating actual facts about the topics he discusses and is instead engaging in, quote, exaggeration and non-literal commentary. Fox persuasively argues that given Mr. Carlson's reputation, any reasonable viewer arrives with an appropriate amount of skepticism about the statements he makes. Whether the court frames Mr. Carlson's statements as exaggeration, non-literal commentary, or simply bloviating for his audience, the conclusion remains the same: the statements are not actionable. Now, whether any of Rittenhouse's claims hold water is sort of irrelevant to the question of whether he can sue someone. In America, you can sue anyone at any time for anything. It just means you might not be successful there at the end if it were to go to trial. It's entirely possible that he might file suit and that some people might settle, potentially for nuisance value, just to make it go away. This is probably what happened in the Nicholas Sandmann case. But the bottom line is that Rittenhouse's lawsuits, legally speaking, almost certainly are going to fail. Now, what if I told you you could watch another LegalEagle video, but this time it's on whether Rittenhouse could be countersued under anti-SLAPP laws if he actually did file any of these defamation suits? Well, this full-length companion video exists and is exclusively on Nebula. Because sadly, if I put it on YouTube, it would probably get demonetized and there's no way you'd ever see it. But Nebula is different. As you've probably heard by now, Nebula is home to tons of exclusive ad-free content, like my first full-length documentary, Bad Law Words Good, my extended interview with Mark Rober, and another exclusive video, Legal Rights, that you definitely want to use, and tons more. All of this exclusive content is only on Nebula, which you can get for free with CuriosityStream. Of course, the reason why all of these videos are only available on Nebula is because they just wouldn't work on YouTube, and they'd probably never be viewed because of the way that the site works. Nebula is a platform for great and unique content that's made by independent educational creators, ones you probably already know, like Tom Scott, Thomas Frank, and Thomas Flight, as well as a whole bunch of other people not named Tom, like Half as Interesting, MKBHD, Real Life Lore, Wendover Productions, Mike Boyd, Minute Earth, Neo, and Real Engineering, and so many others. There's new exclusive content released every single day. And Nebula is creator-owned and creator-operated. And by the way, we've been developing Nebula like crazy, so there's now an iOS app, Android, Apple TV, Roku, Fire TV, and Android TV apps. My fellow creators and I really care about Nebula, and we're thrilled to be partnering with CuriosityStream because they're the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crime, so if you like my videos, you'll love the stuff on CuriosityStream. And the best way to access Nebula and all of the other incredible content is through the amazing CuriosityStream Nebula bundle deal, with its current sales price of less than $15 a year, where you get access to both. And to be clear, that Nebula subscription isn't a trial, it's free for as long as you're a CuriosityStream member. I genuinely don't know a better deal that exists anywhere on the internet where you get two great streaming sites with content that you'll actually enjoy and watch for less than $15 per year at the current sales price. But what's more, signing up will actually help countless independent educational creators beyond just LegalEagle. So please make sure to do so by clicking on the link that's on screen right now, which will take you directly to curiositystream.com/LegalEagle to sign up for both CuriosityStream and Nebula for less than $15 for the entire year. Or you can click on the link that's down below in the description. It's a great way to support educational content and get tons of exclusive content that you'll actually want to watch. Or you can click on this playlist over here with my other real law reviews. So click on this playlist or this link, or I'll see you in court.